Without objection.
Mr. President, today the Senate considers the nomination of yet another unqualified far-right nominee, Chad Radler, who is up for consideration for a seat on the Sixth Circuit Court of Appeals. And let me just say at the outset, any whiff of credibility this nominee might have had as a judicial nominee disappeared the minute he put his name on the Trump administration's absurd legal argument that protections for pre-existing conditions are unconstitutional. And to get a sense of how ridiculous this argument is, you've got to look at a bit of recent history. The Supreme Court ruled in 2012 that the individual mandate was a tax, that it was constitutional, and the Affordable Care Act would stand. For millions of Americans, particularly the ones who wouldn't have to go to bed at night fearing that when they woke up, they could get discriminated against for a pre-existing condition, just like in the old days. And they wouldn't have to under the ACA. They wouldn't have to worry about that anymore. It was a joyful day when the court ruled that the Affordable Care Act would stand, but it was a tough day for the Republican strategists who've been so desperate to bring down the law at any cost. Next, in the process of jamming the Trump tax law through the Congress in late 2017, many Republicans said, let's bring out our old attacks on the Affordable Care Act. They passed an amendment that said there would be no penalty for those who failed to sign up for health insurance, even though everybody understands that those who have coverage often pick up the bills for those who don't. Then in 2018, Republican governors and attorneys general in 20 states made what was really the silliest legal challenge to the Affordable Care Act yet. And that was in the case of Texas versus United States. Here, they said they were going to stipulate that the Supreme Court only upheld the Affordable Care Act individual mandate because it was a tax. Then they said, we established that the Trump tax law dialed the penalty associated with violating the individual mandate down to zero. So that at least had a kernel of accuracy. But let me describe how they got into the back-breaking legal aerobatics next. They argued that because there's no penalty associated with violating the individual mandate, it is no longer a tax, and somehow it has become unconstitutional. Finally, they argued that if the individual mandate is unconstitutional, the whole Affordable Care Act is unconstitutional and ought to be thrown out the window. Now, my own take is that if you are a first-year law student, you'd get a failing grade for that kind of work in constitutional law. But let's stick to the history. The Justice Department has an obligation to defend the laws of the United States. Quaint idea, but that's the role of the Justice Department, defending the laws of the United States in court. The Trump administration, however, said, who cares? Doesn't matter. And they sided with officials who shared their view. And in fact, the Trump Justice Department focused its attack specifically on the Affordable Care Act protections for pre-existing conditions. It said that the mandate was inseparable from two key protections in the law, which therefore ought to be struck down. The rule that bars insurance companies from denying coverage due to pre-existing conditions, and the rule that bars insurance companies from jacking up premiums based on pre-existing conditions. So, a little bit of a recap. A group of officials on the far right who are out of good cases to bring against the Affordable Care Act said, hey, let's try bringing a bad case. The Trump Justice Department, at the president's direction, decided not to fight, but rather to take part in this preposterous attack on the law of the land. And somehow, to the incredible distress of millions of Americans who walk an economic tightrope because they have a pre-existing condition, the Trump people got a Texas judge to rule in their favor. Fortunately, the ACA protections remain in place while the case works its way through the courts. Now, there are colleagues here in the Senate who have objected from the other side of the aisle to what the Justice Department did. Senator Alexander, our friend from Tennessee, who knows a little bit about health care, said, and I quote, this is Senator Alexander, a Republican. Senator Alexander said the Justice Department argument in the Texas case is as far-fetched as any I've ever heard. That's Senator Lamar Alexander, Republican of Tennessee, chair of a key committee that works with us on the Finance Committee. Justice Department argument, according to Senator Alexander, is just light years from a reasonable and rational position. So then the Trump administration went ahead and threw out centuries of Justice Department tradition, honored by Republicans and Democrats, of defending laws as long as there is a non-frivolous argument in their favor. And they didn't decide to throw out that vital legal tradition in a case involving some obscure, out-of-date statute. They chose, in effect, to debase the Justice Department and undermine the rule of law in order to attack protections for pre-existing conditions. Chad Radler is the Trump appointee who stepped up and said, sure, you can put my name on that legal brief. So what Chad Radler was essentially saying is it was just fine with him to go back to the days in America when health care is for the healthy and wealthy. That's really what you have if you allow discrimination against those with pre-existing conditions again. If you're healthy, nothing to worry about. If you're wealthy, you can write out a check and cover the payments for a pre-existing condition and the health services you need. But make no mistake about it, what Chad Radler was interested in doing by putting his name on that legal brief was to take America back to yesteryear, when the insurance companies could beat the stuffing out of somebody with a pre-existing condition and find every manner of reason to not get them affordable care. And people were stuck in their jobs because of something called job lock, where they couldn't move to another company even when they got a promotion because they wouldn't be able to get coverage. So that's what Chad Radler wanted to inflict on Americans. And the case he worked for is so obviously political and meritless, 3 career Justice Department attorneys withdrew from it. One senior official, an individual who'd been praised for 20 years of extraordinary service, actually resigned. But Mr. Radler said, that's okay with him too. We'll take America back to the days when health care was for the healthy and wealthy. I don't really much care that senior officials, non-political officials in the department, are leaving because this was such an extreme way to handle this case. Mr. Radler said all of this is okay, and he'll be the public face of attacking basic protections for 133 million Americans with pre-existing conditions. The very same day, the president announced his nomination to sit on the powerful Sixth Circuit, a lifetime appointment on the federal bench, an extraordinarily important position. If there's somebody following this nomination at home, you just might ask yourself, doesn't that sound like a quid pro quo? I said yesterday, Mr. President, as the ranking Democrat on the Senate Finance Committee, where we pay for much of American health care, Medicare, Medicaid, Children's Health Program, tax credits available under the Affordable Care Act. We have the tax exclusion that's available to employers that on our committee, and the President of the Senate is a new member of the committee, you get a chance to review the credentials of lots of individuals who are involved in these decisions, where the Finance Committee is really faced with the question of how to make the best use of what is really $2 trillion or thereabouts of health care spending. And I will tell you, in this area that's so important, protecting people with pre-existing conditions, the Trump administration just seems to have, with one nominee after another, an inexhaustible supply of far-right pretenders, persons who claim that they will be for protections for pre-existing conditions, only to turn around quickly and fight to take them away. So it ought to be clear that this isn't a routine nomination. Chad Radler thinks insurance companies should be able to deny care to people with a pre-existing condition. Colleagues, if you vote for Chad Radler, you are casting a vote to endorse the position of turning back the clock, rolling back time to the days when insurance companies could discriminate against those with a pre-existing condition. Now, if Mr. Radler's history began and ended with the legal brief attacking pre-existing condition protections, that would be disqualifying in my view, but there's more. He signed the Trump Justice Department legal brief greenlighting discrimination against LGBTQ Americans in the Masterpiece Cake Shop case. He defended the transgender military ban. He defended the Muslim ban. He defended family separation at the border. I'm just going to close by way of saying, I think this nomination is a byproduct of what happens when the Senate abandons a long-held practice of consulting with home state senators on nominees. Since the early 1900s, it's been tradition for the Judiciary Committee to seek input from senators on judicial nominees from their home state. Lower court nominees traditionally don't move forward until those home state senators give the green light. They do so with what are called blue slips. In this case, the nominee is from Ohio, and the Majority Leader, Mitch McConnell, is in the process of blowing that tradition up and moving this nominee over Senator Brown's objection. In 2009, when Republicans were in the minority, Mitch McConnell, all of his colleagues fought to protect the blue slip tradition. They wrote everybody in sight, President Obama, Senator Leahy, protect it. They wrote, and I quote, "We hope your administration will consult with us as it considers possible nominations to the federal courts from our states." So they made it very clear a few years ago that they strongly supported this. But here they are, blowing up a century-old tradition of bipartisanship on judicial nominees after defending it. This issue came to a head last year when the Senate took up the nomination of Ryan Bounds to the Ninth Circuit, despite objections from my Oregon colleague, Senator Merkley, and I. We were able to block that nomination. It was the right thing to do. This was a nominee who we felt had not been straight with our Judicial Selection Committee. As Oregon's senior senator, I had been dealing with these nominees, Democrats and Republicans, for years, but our Judicial Selection Committee had never felt so misled. So Senator Merkley and I led the fight, and we were successful to defeat that nominee. Now, the White House still wants, apparently, this body to act as a rubber stamp and just approve one nominee after another without any questions. I want my colleagues to understand that by moving this nomination forward, they're going to be responsible for creating a new reality, in effect, hot-wiring the process for considering judicial nominees in a way that will take us back again to a more partisan approach. The blue slip process, the bipartisan blue slip process, has worked for over a century. What's going on now would end it. This is a breach of bipartisan protocol that has further driven the judiciary to a partisan extreme. Following these actions by the Trump administration and majority, I have serious questions, if you continue this, whether the current structure of the courts is going to survive. Mr. President, colleagues, Chad Radler does not deserve a lifetime appointment to the Sixth Circuit. The moment he put his name on the Trump administration's absurd legal attack on protections for pre-existing conditions, he revealed that he was going to be a partisan all the way, and on top of it, he was going to exercise poor judgment. He has been a defender of discrimination in multiple forms, defending the indefensible abuse of vulnerable migrant families at our border, and at this point, he cannot claim to be close to the standard of impartiality and even-handedness that a senator ought to be able to expect from any judicial nominee. I intend to vote against Chad Radler. I urge my colleagues to join me, and with that, I yield the floor.